Hello, everyone. Welcome to our chat with Mark Davis tonight. My name is Talia. I'm the events manager here at Flyleaf Books. Let me just tell you a little bit about what we're doing in terms of events before we begin. So we are doing about 1 to 3 events per week through the rest of the fall up until Thanksgiving, and then we will pause events through the holiday season. For next week, I'll just give a quick little rundown of a few of the things we have coming up. On Monday, the 9th, we have 2 short story authors who write Southern fiction. That's Matt Randall Owain and Ashley Bryant Phillips. They each have a new book of short stories out. Then Wednesday, we have John LeBar and Alan Paul, who are presenting a book about basketball in North Carolina. And then we have Sebastian Matthews and Daniel Wallace on Thursday the 12th. Sebastian Matthews has a new book about repairing divides in our country, and Daniel Wallace, you may know, is the author of Southern fiction classics like Big Fish. All right, so let me introduce our author tonight. Mark Davis currently serves as an associate judge on the Supreme Court of North Carolina and has been an appellate judge since 2013. Prior to that, he also served as general counsel to the governor of North Carolina. He also spent 17 years as an attorney in both the private and public sectors. In 2012, he was awarded the Order of the Longleaf Pine. Justice Davis is the author of A Warren Court of Our Own, The Exum Court, and the Expansion of the Individual Rights of North Carolina. He and his wife, Marcia, live in Raleigh with their 3 children. Find Mark on Facebook and Twitter at Judge Mark Davis. All right, Mark, I will hop out and let you give your presentation about A Warren Court of Our Own, and then I will pop back at the end to take any questions from the audience and read those out to you. All right, thanks. Take it away.
Well, thank you, Talia. I'm delighted to be with all of you tonight. So happy to talk about this book, A Warren Court of Our Own. I wrote it about the court on which I ended up serving on, the North Carolina Supreme Court. The book is about the period of the Supreme Court in this state between 1986 and 1995, when a man named Jim Exum was Chief Justice. And I wrote about this particular era of the court because to me it's sort of a Mount Rushmore court. All the judges who served on it were luminaries whose names will live on and on in North Carolina legal circles for decades to come. In addition to Jim Exum himself, you had 4 future Chief Justices of the court: Burley Mitchell, Henry Fry, Beverly Lake Jr., and Sarah Parker. You also had some very brilliant Associate Justices like Willis Wichard, Harry Martin, and Lewis Meyer. At the time I wrote the book, 7 of the 9 justices who served on the court were still alive and were kind enough to let me interview them extensively, which I greatly enjoyed. I also got to interview about 65 attorneys who practiced before the Exum court, law clerks on the court, law professors, and court personnel, because I really wanted a balanced portrait of the court. And Jim Exum himself was kind enough to write a foreword for the book. Is very well to the period of the U.S. Supreme Court, 60s, when Earl Warren was Chief Justice, which, as many of you know, was a very transformational period for the U.S. Supreme Court. There was a great expansion with regard to the Federal Bill of Rights. And the premise of my book is that, admittedly, in a bit of a small, it really modernized North Carolina law in a way that hadn't occurred up to that point. So I want to talk for a few minutes about 2 primary topics that are discussed in much more detail in the book, and then be delighted to answer any questions you might have. The first topic is how the Exum Court came to be, and this is the subtext is the historical
Mark, it looks like we lost you. Could you refresh your page? Sorry about that. Looks like there is a Wi-Fi problem. We will get Mark back on screen in just a moment. Thank you for your patience, everybody. Mark is just connecting back. It looks like there is a problem with Mark's Wi-Fi. I'm going to continue to try to get him online. If you'd like to stay with us, please do. We will do our best to get that sorted out.
Talia? I think you mute.
Yeah, we've got you. All right, great. Thanks for
Sorry
your
about
patience,
that.
everyone.
We're
Sorry
all,
about that.
it's fine. I think we're all sort of at the mercy of Wi-Fi these days, aren't we?
We are, definitely. That's what it is to be in 2020.
It is indeed. So I think perhaps the last thing you heard me say was that it was back in 1896 when the last Republican was elected to the Supreme Court.
That sounds right.
Okay. So what you had was a de facto appointive system where Democratic governors would appoint Democratic justices who would serve as long as they wanted to until they reached mandatory retirement age. And so for most of the 20th century, all three branches of North Carolina government were controlled by Democrats. But in the 1960s, the National Republican Party embarked on what they called the so-called Southern Strategy, which was designed to get more Southern voters into the Republican fold. And 1972 was a successful year for Republicans in states like North Carolina. Richard Nixon carried the state as president. Jesse Helms won the first of his U.S. Senate terms, and a man named Jim Holshouser became the first Republican governor in anyone's memory. Now, in 1976, things sort of went back to normal. Jimmy Carter carried the state as president as a Democrat. Jim Hunt won the first of his 4 gubernatorial terms as a Democrat. But if you flash forward to 1984, things get really interesting. You had Ronald Reagan, very popular in North Carolina and easily carrying the state. You had Jesse Helms winning a very bitterly contested U.S. Senate race against Jim Hunt. And you had another Republican, Jim Martin, who was elected as governor. So far, none of the top ballot success had trickled down to statewide judicial candidates, and the Supreme Court remained all Democratic. I mentioned a minute ago that Jim Holshouser was elected as a Republican governor in 1972. He served 1 term and did not have the opportunity to appoint anyone to fill a vacancy on the Supreme Court, but Jim Martin had a little more luck in that regard in 1984. Actually in 1985, a year into his first term, there was retirement on the court, and he appointed a Republican woman named Rhoda Billings, a highly regarded professor, to fill the vacancy. Then in 1986, in June, a year later, things got really, really interesting. I'm going to talk about a series of events for the next few minutes, and please keep in mind as I do so, all of these events happened between June of 1986 and North Carolina's regularly scheduled elections in November of 1986. In June of 1986, Chief Justice Joseph Branch unexpectedly announced his retirement. Now, the longstanding tradition in North Carolina at that time was when there was a vacancy for the position of Chief Justice, the governor would appoint the senior associate justice, the one who had served the longest on the court, to be the new Chief Justice. And in 1986, that was Jim Exum. He had been on the court for 11 years. So the question was, would Governor Jim Martin follow the tradition? But we had a wrinkle here because Governor Martin was a Republican and Jim Exum was a Democrat. And so the question was, what was Governor Martin going to do? Well, he was lobbied very strongly, both inside and outside the North Carolina legal community, to follow tradition and appoint Jim Exum as the new Chief Justice. But Governor Martin had a mind of his own, and it was important to him that North Carolina truly a two-piece state in all respects. And so he shocked everybody by elevating not Jim Exum, but Rhoda Billings to be the next Chief Justice. Among the people I interviewed for the book was Governor Martin, who's now retired and lives outside of Charlotte. And during the interview, I asked him point blank, I said, Governor, why didn't you follow the North Carolina tradition and appoint Jim Exum as Chief Justice? And he smiled at me and said, Mark, that wasn't a North Carolina tradition. That was a Democratic Party tradition. I thought that was a good answer. In any event, Jim Exum had a decision to make at that point. He wanted to be Chief Justice. He felt like he had been unfairly passed over. And so he could have stayed on the court. His associate justice seat was not on the ballot in 1986. He could have bided his time and tried to become Chief Justice another year. But he really wanted the job. He thought he had been unfairly passed over, but he also thought it would be unseemly for two members of the court to run against each other. So in a courageous move, he resigned his seat as an associate justice and announced he was going to run against Rhoda Billings, who had to run to keep her seat as Chief Justice. And keep in mind that by a quirk of North Carolina election law, even though she had just been appointed Chief Justice in June, she had to run to keep her seat 5 months later in the regularly scheduled November elections. So Jim Exum resigned. Governor Martin appointed a Republican named Robert Browning to fill his vacancy. And back when he had elevated Rhoda Billings, he had appointed another Republican named Francis Parker from Charlotte. So now all of a sudden you had a 4-3 court, 4 Democrats, 3 Republicans, and a Republican Chief Justice. And to make it even more interesting, 2 of the other incumbent Democrats on the court were scheduled already to be on the ballot to keep their seat in the November elections. So of the 7-member court, you had 5 of them up on the ballot. And again, it's a 4-3 court for the first time in anyone's memory. Now, the focus in the media and among the public was on the Chief Justice race, Jim Exum challenging Rhoda Billings. And for the first time in North Carolina history, really, we saw negative campaigning against a judge for votes that he had taken as a judge. A grassroots organization called the CCC, the Citizens for a Conservative Court, was formed for the sole purpose of campaigning against Jim Exum. And what they did was they picked one specific issue, the death penalty. Jim Exum was known to be a strong opponent of the death penalty. As a legislator, he had sought to abolish it unsuccessfully in North Carolina. And as a member of the Supreme Court, he had frequently voted to overturn a death sentence conviction, usually in dissent. He didn't believe the death penalty was unconstitutional in all circumstances, but he believed it was being unconstitutionally applied in North Carolina. So the CCC would hold rallies in counties across the state where prominent murder cases had arisen, in which Jim Exum had voted to overturn the defendant's death penalty. And they would hold demonstrations accusing him of being too liberal and being soft on crime and things like that. This upset a lot of lawyers who liked Jim Exum and respected him, and they would hold counter demonstrations across the street and try to explain to people why Jim Exum was just doing his job. So as we sit here today in 2020, in the age of super PACs and Citizens United and all the outside money we see in judicial races today, it all seems so primitive. And maybe it was primitive, but this is really how it started in North Carolina. So what ultimately happened in November after all this excitement in what was usually a very boring and dry set of judicial races for the Supreme Court in North Carolina? Well, it was very anticlimactic. The Democrats all won, as they always had, for whatever reason, and the Supreme Court went back to being a 7-0 court, all Democrats. So let me turn to the second topic, which is why the Exum Court was significant from a legal perspective. The members of the Exum Court were all very collegial. They got along very, very well. They were all of the same political party, as I've said. They all shared many demographic characteristics and backgrounds. And yet, despite all of those similarities, they had very different views on the proper role of judges. And their judicial philosophies were in conflict. And that topic is really the heart of the book. This is what interested me the most as I was writing the book. From my perspective, Jim Exum and the senior associate justice during the 8 years of the Exum Court named Lewis Meyer were the 2 intellectual centers of gravity on the court. And each of them was on the opposite ends of the spectrum in cases involving individual rights. Jim Exum was sort of the classic stereotype of the liberal judge. He tended to see the law in very idealistic terms. He was sympathetic to the underdog, and he was not opposed to overruling prior decisions of the Supreme Court if he thought it was appropriate. Lewis Meyer, conversely, was sort of the classic stereotype of the conservative judge. He was a so-called law and order judge who usually ruled in favor of the government and big business, and he very strongly believed that policy decisions were strictly reserved for the legislative branch rather than the judicial branch. Exum usually had a reliable voting majority on the court in these types of cases, so that meant Meyer was often in dissent, usually by himself. And in his dissents, and I quote from them as much as I can in the book, he would make a lot of scathing comments about how he thought the majority was being very result-oriented and that he was improperly making the law, or the majority was improperly making the law or legislating from the bench, which were two things that he really thought judges should never do. So in the book, I talk about maybe 60, 65 landmark cases decided by the Exum Court during this 8-year period from 1986 to 1995. And I tried to divide them up into subject areas, including the North Carolina Constitution, criminal law generally, the death penalty, personal injury law, employment law, and workers' compensation law. And I'll just talk very, very briefly generally about each of these areas. Many years, particularly during the Warren Court, because civil libertarians were winning all their cases at the U.S. Supreme Court under the Federal Bill of Rights, and there really was no need to look to state constitutions like North Carolina's. But after Earl Warren retired and the U.S. Supreme Court began tilting to the right a bit, and a lot of civil libertarians around the country started looking to state constitutions as an additional source of individual rights. And that happened in North Carolina as well. Jim Exum and another member of the court, Harry Martin, were very big on this notion. They would actually go around the state and try to encourage lawyers to bring cases under the North Carolina Constitution and try to explain that the North Carolina Supreme Court had the ability to interpret individual rights more broadly than the U.S. Supreme Court had interpreted them. So there was a great expansion of the Declaration of Rights contained in the North Carolina Constitution during the Exum Court. With regard to criminal law generally, the Exum Court repeatedly demonstrated a willingness to overturn criminal convictions on a variety of different legal theories. They were much more willing than prior versions of the court had been to give a defendant a new trial based on in errors. The Exum Court was much likely to say that the errors were not harmless and that the defendant was entitled to receive a new trial. I read a separate section about the death penalty because that was such an important part of the caseload during the Exum Court. Each session of court, they heard many, many death penalty cases, far more than courts here today. And one statistic that still jumps out at me, as much as I've spent talking about this book, it still amazes me every time I talk about it. The Exum Court heard 163 death penalty challenges over its 8 years. And of those 163 death penalty appeals, it overturned the defendant's death penalty conviction 102 times for a reversal rate of 62%, which is really an astounding figure. In modern days, if our Supreme Court overturns any death penalty conviction, it's a very big deal, and it doesn't happen very often. But they did it 102 times in 8 years. Turning to civil law, I spend a good bit of time in the book talking about personal injury cases, because that was another area that the Exum Court had a big impact on North Carolina law. The Exum Court was willing to expand the remedies available to individual plaintiffs who brought personal injury lawsuits, far greater than the Supreme Court had ever done before, in cases where individuals were injured and sued corporations or sued the government. The Exum Court was much more receptive to their claims than prior versions of the court had been. In employment law, the Exum Court heard a number of important cases and gave much greater rights to employees who were suing their employers than had ever existed in North Carolina law before. North Carolina has always had a doctrine called employment at will, which means if you don't have an employment contract and you're an employee, your employer can pretty much fire you for any reason they want to, obviously as long as they don't violate federal law or the Constitution. But other than that, they pretty much have free reign to fire an employee for any reason or no reason. And the Exum Court for the first time created an exception to that rule, which said that an employer could not fire an at-will employee for a reason that violated public policy. And this was a big deal in employment circles because for the first time, it showed a willingness of the Supreme Court to cut back on the employment at will doctrine. I also talk in the book workers' compensation cases. Workers' compensation is usually a very dry, most people would say cut and dried, non-controversial area of the law. It involves, of course, employees who are injured on the job and how much monetary benefits they should receive. And there are a set of statutes that have tables that provide a certain amount of monetary benefits for virtually every type of injury you could imagine. So it's usually not a source of disagreement, but on the Exum Court, it was a very big source of disagreement between Jim Exum and Lewis Meyer. And it really epitomized the nature of the differences between the two of them from a judicial philosophy perspective. Jim Exum, as I said earlier, he would always sympathize with the underdog, and he believed that workers' compensation laws should be interpreted very broadly to give the maximum amount of recovery to injured employees. Lewis Meyer, conversely, took a different view. He thought that the workers' compensation laws had been enacted as sort of a carefully crafted compromise between the North Carolina legislature, the employers of the state, and the employees. And he thought that judges should interpret the workers' comp laws very strictly, not generously, to not give injured workers any more rights than they would ordinarily have. So this too was a profound source of disagreement between the two of them, and it's very much reflected in the cases that I talk about in the book. All things must come to an end, and so too the Exum Court. By the end of 1994, Jim Exum was worn down. He was well below the mandatory 72-year-old retirement age for judges in North Carolina. He was actually in his early 50s, but he just was really worn down, particularly by the death penalty cases, and he shocked everyone in the legal community in North Carolina by suddenly announcing his retirement at the end of 1994. He went back to Greensboro to practice law and teach at Elon University. In what some would call poetic irony, Lewis Meyer also left the court at that same time. He didn't leave by choice. He was opposed in the Democratic primary in the 1994 elections because he was viewed as being too conservative by a lot of Democrats. And he lost his race, and he was appointed as a special Superior Court judge. He remained in that role until the end of his life in 1999. Let me just finish where I left off, or where I started on the postscript to partisan elections in North Carolina. 1994 turned out to be the breakthrough electoral year for Republicans in North Carolina's judiciary. Beverly Lake Jr. and a gentleman named Bob Orr both won statewide races for the Supreme Court as Republicans, thereby shattering the glass ceiling, if you will. 5 years later, by 1999, Republicans had a majority on the court, and somewhat remarkably, in light of the history that I gave you earlier about the long century of Democratic dominance, by 2002, there was only one Democrat left on the North Carolina Supreme Court. But North Carolina is the ultimate purple state, and by 2016, Democrats had reclaimed a majority on the court, which still exists. So I think it's safe to say that North Carolina is now truly a two-party state, as Governor Martin hoped it would be, not only in the legislative and executive branches, but also in the judicial branch. So I'm going to stop there. Again, all of these subjects are talked about much more fully in the book, but I will stop there, and I hope there are some questions. Be delighted to try to answer any that anyone might have about the book, about the court, or about anything else that may be on your mind. So Talia, let me kick it back to you.
Yeah, absolutely. Does anybody watching have any questions that they would like to pose to Mark tonight? I have a question. How do you see this history informing what might be the future of the North Carolina judicial system?
Well, it's a good question. So we've sort of, the legislature has gone back and forth on partisan judicial elections in North Carolina. Up until 2002, as I've said, they've always been partisan. The legislature tried an experiment between 2002 and 2014 in which judges no longer ran partisan races. So on the ballot, voters did not know what political party a judge belonged to. But then in 2014, the legislature went back to partisan judicial races, which is what we have currently. So it'll be interesting to see whether North Carolina ever goes back to nonpartisan races, or whether North Carolina ever amends its constitution to do away with the electing judges in the first place and going to some sort of an appointive system the way some states have. But I do think the Exum Court still has an influence on modern law. Virtually all of the cases I talk about in the book are still good law in North Carolina. They've not been overturned. And so the Exum Court, I do think, continues to have a large influence on the court today.
Mm-hmm. Yeah, that's interesting. And at least until, until the precedent still stands, which is good. All right.
So you're breaking up a little bit. Talia, can you hear me?
Yes, I can hear you. Can you hear me?
Breaking up a good bit. I can hear you now.
All right. Well, it looks like we do not have any more questions tonight, so we're going to wrap it up. If you are watching and would like to purchase Mark's book, you can click the link beneath our faces to purchase a copy through his publisher. Flyleaf is now open for limited browsing. Our browsing hours are Tuesday through Saturday from 11 to 3. And our online ordering is always open. The phones are Tuesday through Saturday, 11 to 5, if you'd like to order over the phone. All right. Have a good night, everyone. Thank you so much to Mark. Stay safe. Unclench your jaw if you're feeling stressed. I know that I've been trying to do that every so often. And have a great night. Thanks so much, y'all.